Welcome back, everyone. We're jumping straight into some interesting legislative activity happening in the House, focusing on voter registration.
That's right. We'll be looking at two specific items: House Bill 22, known as the Safeguard American Voter Eligibility Act, or a SAVE Act, and also House Resolution 294.
And if you find this kind of breakdown helpful, please do take a second to like this and subscribe to the show. It really helps us out.
Absolutely. So our goal today is to unpack what these documents propose, what changes they might bring, and what the potential impacts could be.
Okay, sounds good. Let's start with House Resolution 294. It sounds like maybe a procedural thing first. What did it actually do?
Yeah, you got it. House Resolution 294 basically set the stage for the House to consider several different pieces of legislation. And importantly for our discussion, it included House Bill 22.
Oh, okay. So it wasn't policy itself, more like setting the rules of the game.
Exactly. It's key to understand House Resolution 294 didn't change any laws about voting. It's a procedural rule. Came out of the House Rules Committee. Think of it like setting the terms for the debate.
So it laid out how the discussion and the voting would proceed on these bills.
Precisely. It established things like, how much time would be allowed for debating those specific bills, including the Safeguard American Voter Eligibility Act, and maybe what kinds of amendments could be offered.
Right. So without this rule getting passed first, the House might not have even debated House Bill 22 in this specific way.
That's the idea. It essentially paved the way for the House to take up House Bill 22. So they're connected, but they deal with very different things.
One's the process, the other's the substance.
Exactly. House Resolution 294 facilitated the action on House Bill 22, but the content, what each is trying to do, totally separate.
And the fact that House Bill 22 was included in this rule, does that tell us anything?
Well, it does suggest that House leadership saw bringing this bill to the floor as, a priority. It was intentionally included in the plan.
Makes sense. Were there other bills bundled into this same resolution?
Yes. House Resolution 294 also covered the consideration of, Senate Joint Resolution 18, Senate Joint Resolution 28, and House Resolution 1526. It's pretty common for the House to manage its floor time this way, grouping things under one rule.
Okay, that clears up the procedural side. Now let's really get into the substance. House Bill 22, the Safeguard American Voter Eligibility Act. What are the core requirements here?
Right, so House Bill 22, introduced by Representative Chip Roy, its main thrust is amending the National Voter Registration Act of 1993, the NVRA. And the big change is this. It would require documentary proof of U.S. citizenship to register to vote in federal elections.
Documentary proof. Wow, okay, that sounds like a pretty significant departure from the current system.
It really is. The bill specifies this proof would be needed no matter how you register in person, by mail, online, doesn't matter.
So the current system where you check a box and sign, affirming you're a citizen, that wouldn't be enough anymore for federal elections.
That's right. Under this bill, it wouldn't. And it goes further. It directs states to basically set up ongoing programs to ensure only citizens are registered. This means actively identifying and removing non-citizens from the rolls using certain data sources.
Okay, so what kind of documents would actually count as proof? I imagine the list is quite specific.
It is very specific. The bill lists acceptable forms. One is an ID that meets the Real ID Act standards, but, and this is a key point, it has to actually indicate the person is a citizen. Most Real ID compliant driver's licenses don't explicitly state citizenship.
Okay. What else is on the list? A passport, presumably.
Yes, a valid U.S. passport would work. Also an official U.S. military ID card, but you'd also need a military record of service showing a U.S. birthplace alongside it.
So the military ID alone isn't enough?
Not according to the text, no. You'd also need that service record showing the birthplace. Similarly, a valid government photo ID, federal, state, or tribal, that shows your birthplace was in the U.S. would be accepted.
Okay, those seem like primary citizenship documents. Are there other pathways if someone doesn't have those specific things readily available?
Yes. There's another category. You could use a valid government-issued photo ID from federal, state, or tribal government, even if it doesn't show a U.S. birthplace. But you have to present it with at least one other specific document from another list.
Okay. And what's on that list?
That includes things like a certified birth certificate meeting, you have very specific criteria who issued it, where it's filed, names, dates, signature, seal, the whole thing, or an extract from a U.S. hospital record of birth created at birth showing a U.S. birthplace,
Okay.
or a final adoption decree showing your name and U.S. birthplace, or a consular report of birth abroad if you're a citizen born overseas, or related State Department certification.
Certificates for naturalized citizens, too.
Yes, a naturalization certificate or certificate of citizenship issued by Homeland Security or other federal documents under the Immigration and Nationality Act. And one more, an American Indian card from DHS with a specific classification, KIC.
That is quite a detailed list. It seems like there are options, but each one has very particular requirements. What about common situations, like someone changing their name after marriage? Their ID might not match their birth certificate.
That's a good point. The legislation reportedly directs states to set up alternative processes for those kinds of discrepancies. So for a name change due to marriage, they might have to accept supplemental documents, like maybe a marriage certificate, to bridge the gap between the ID and the birth certificate.
But the states would have to figure out those exact processes themselves.
It seems that way. How exactly those alternative processes would work could vary from state to state, which, could add another layer of complexity for both voters and election officials.
Definitely sounds complex. Okay, let's shift to the why. Why are proponents, the supporters of this bill, saying it's necessary? What's the main argument for the Safeguard American Voter Eligibility Act?
The primary argument you hear from supporters is that it's needed to prevent non-citizens from voting in federal elections. They frame it as a way to safeguard election integrity and restore public confidence in the process.
Sort of reinforcing that idea of American elections belong to American citizens.
Exactly. That phrase comes up. Sponsors like Representative Roy and Senator Mike Lee argue this is about preventing a potential foreign influence and giving states the tools they feel they need to stop illegal registrations. They often present it as, common sense, constitutionally grounded measure.
Do they point to specific examples or evidence to back up this need?
Sometimes they cite instances where non-citizens have reportedly been found on voter rolls. They also sometimes point to local ordinances, like the one in New York City that allows non-citizens to vote in local elections, arguing this shows a need for clear federal standards for federal elections.
Any connection to other political discussions?
Yeah, sometimes it's linked to a past presidential executive order related to proof of citizenship. And you see support from conservative groups like Heritage Action, who often tie it into broader election integrity reforms, similar to voter ID laws at the polls.
So the underlying idea is that the current system, just affirming citizenship on a form, isn't secure enough.
That's the core premise for supporters, yes.
Yeah.
That the attestation system is insufficient. And tied into that is this narrative about a confidence gap in elections.
Right. We hear a lot about restoring confidence.
Absolutely. Proponents argue measures like this are vital to reassure Americans that elections are secure and legitimate. It's interesting because this argument persists even when most studies and official reviews find that non-citizen voting in federal elections is actually quite rare.
So the push for the bill might be about more than just the numbers of documented cases.
That seems plausible. It could be serving a purpose for its supporters, beyond just addressing a statistical occurrence. Maybe it's aimed at reassuring certain voters or perhaps leveraging existing public distrust or anxiety about election processes, regardless of the actual frequency of non-citizen voting.
Okay, that helps understand motivation behind it. Now, let's pivot to the potential consequences and criticisms. If the Safeguard American Voter Eligibility Act became law, what are the assessed implications?
The implications could be pretty far-reaching. First off, it would significantly change the existing federal framework, particularly the NVRA and also parts of HBA, the Help America Vote Act.
How would it clash with the NVRA specifically? I thought that was about expanding access.
Exactly. The NVRA was largely about making registration easier and more convenient. This bill, with its proof requirement, really runs counter to that principle. It could undermine several key NVRA mechanisms.
Like what? Which parts would be most affected?
Well, think about mail registration. Sending in a form would likely become just the first step, requiring a follow-up in-person visit with documents. That severely limits its convenience.
And an online registration.
Same issue. Online systems would be disrupted because you'd still need to figure out how to get that physical document verification done, likely in person. Agency-based registration, like at the DMV or public assistance offices, that gets way more complex because the IDs people typically have for those services often won't meet this bill's specific citizenship proof requirements.
So getting registered while getting your driver's license might not work the same way.
It would likely become much harder, yeah. and voter registration drives. Conducting those for federal elections would become incredibly difficult, maybe almost impractical, because volunteers couldn't just collect forms. They'd somehow have to facilitate document presentation.
It really sounds like it shifts the burden, doesn't it? From the election office verifying things on the back end to the individual having to produce these specific documents up front.
That's a perfect way to put it. It's a fundamental shift in who bears the burden of proof for citizenship at the point of registration.
And that shift leads to major concerns about voter access, right? Could this actually prevent eligible citizens from voting?
That's the single biggest concern raised by critics. They argue these requirements would significantly impede access and could potentially disenfranchise millions of eligible American citizens.
Millions. Are there estimates on how many people might lack the required documents?
There are. The Brennan Center, for example, estimated about 9% of the U.S. citizen voting age population,
Yeah.
which translates to something like 21 million people don't have ready access to the kinds of documents specified, like a current passport or birth certificate. State-level studies in places like Texas and Georgia found similar percentages, around 7% and 10% respectively.
And that doesn't even count the complexity of name changes.
Right, the numbers could be even higher when you factor in people whose names on their ID don't perfectly match their birth certificate, requiring those extra steps we talked about.
So potentially millions of eligible voters facing hurdles, contrasted with what most analyses say is very rare non-citizen voting.
That's the core critique regarding proportionality. Critics argue you're potentially disenfranchising a huge number of eligible voters to address an issue that, while legal, happens very infrequently, often due to errors rather than intent.
And are there specific groups that might be hit harder by these requirements?
Yes, analyses suggest the impact wouldn't be evenly spread. Married women, for instance, and anyone else with a legal name change could face significant hurdles due to document mismatches. One estimate suggested potentially up to 69 million American women have name changes that could complicate this.
Who else?
Younger voters, say 18 to 29, tend to be less likely to have passports or easily accessible birth certificates, according to those Texas and Georgia studies. Elderly voters might struggle with obtaining documents or the physical act of presenting them, especially if they have mobility issues. One survey indicated over 14% of people over 80 lack ready proof of citizenship documents.
What about income or location?
Those are factors too. Low-income and working-class citizens might face barriers due to the cost of obtaining documents, like a certified birth certificate, or needing to take time off work for an in-person visit. Passport possession rates are also generally lower among lower-income groups. Rural Americans might face significant travel burdens to present documents in person, especially in states with fewer offices. And passport ownership can be lower in some rural areas as well.
And concerns about minority groups?
Absolutely. Civil rights groups like the ACLU argue this could disproportionately affect people of color and other marginalized communities. This could stem from systemic inequalities, historical disenfranchisement making document access harder, potentially lower rates of possessing the specific required documents in some groups. Hispanic voters in those Texas-Georgia studies had lower rates, for example, and a greater reliance on registration methods like voter drives that would be curtailed.
Are there other specific populations that could face unique challenges?
Yes, quite a few. Military personnel and their families could run into issues because, as we mentioned, standard military IDs aren't sufficient under the bill. They'd need supplemental birth proof, which can be tricky with frequent relocations. Naturalized citizens, while they have citizenship proof, might face heightened scrutiny or bureaucratic hurdles navigating the system.
That's right, they get certificates.
They do, but sometimes getting those documents presented and accepted smoothly can be an issue. Survivors of natural disasters who've lost vital documents could be completely blocked. And transgender individuals whose identity documents may not align neatly with birth records could face significant difficulties and potential privacy invasions.
It really paints a picture of potential barriers across many different groups. What about the election officials themselves? What would this mean for their jobs and potential legal risks?
It would almost certainly mean a massive increase in workload and costs for state and local election offices. They'd have to handle the intake, inspection, and verification of these physical documents for potentially every single new federal registrant, and maybe even for updates like address changes.
And who pays for that?
That's a huge concern. It could essentially be an unfunded mandate, placing significant new costs on state and local governments without federal funding to cover it.
You also mentioned mandates about keeping the voter lists clean.
Yes, the bill requires states to implement programs to identify and remove non-citizens, using database comparisons and potentially retroactive audits. While accurate lists are crucial, the risk with aggressive purge programs is always accidentally removing eligible voters due to data errors or faulty matches.
And the penalties for officials seemed really severe.
They are. The bill includes potential criminal penalties up to 5 years in prison for an election official who registers someone for a federal election without getting that specific documentary proof, even if the applicant is a citizen or if it was just an administrative error.
Wow, even for an error.
That appears to be the case based on the text. Plus, it creates a private right of action, meaning individuals or groups could sue election officials directly over alleged violations. This combination of criminal penalties and lawsuit threats could make officials extremely risk-averse.
Potentially leading them to deny registrations even when someone might be eligible, just to be safe.
That's the fear, yes. And for states that don't currently require proof of citizenship for their own state and local elections, which is most states, they'd have to create and manage two entirely separate registration systems.
A federal list and a state local list.
Exactly. One with the proof of citizenship requirement for federal races and one without it for state and local races. That would inevitably lead to voter confusion, which elections am I registered for, and increase the potential for administrative mistakes.
Okay, so putting it all together, what's the core critique about whether this is necessary or proportional?
The main critique boils down to this. Substantial evidence from studies, audits, and court cases shows that intentional, widespread non-citizen voting in federal elections is largely non-existent. It's extremely rare.
And current law already prohibits it, right?
Yes, federal law already makes it a felony for a non-citizen to vote in federal elections, carrying serious penalties like fines, imprisonment, and deportation. So critics argue H.R. 22 imposed an incredibly burdensome requirement on millions of eligible citizens to solve a problem that is statistically tiny.
Sort of like using a sledgehammer to crack a nut or, as you mentioned earlier, sifting the whole ocean for one seashell.
That's the analogy some use, yes, that the potential harm to voter access is vastly out of proportion to the documented scale of the problem it claims to address.
Has this kind of requirement been tried before? Are there legal precedents?
There are. Kansas implemented a proof of citizenship law a number of years ago. It ended up blocking tens of thousands of eligible voters from registering, faced numerous lawsuits, and was ultimately struck down by federal courts as unconstitutional and violating the NVRA.
And the Supreme Court weighed in on a similar issue too, didn't they?
Yes. In Arizona v. Inter-Tribal Council of Arizona back in 2013, Arizona tried to require documentary proof of citizenship on top of the federal voter registration form, which relies on attestation. The Supreme Court said Arizona couldn't unilaterally add requirements beyond what the NVRA specified for the federal form.
H.R. 22 tries to get around that by changing the NVRA itself.
Exactly. It attempts to amend the federal law that the Supreme Court relied on in the Arizona case. However, the underlying constitutional principles about not placing undue burdens on the right to vote would still apply. Similar proof of citizenship attempts in other states, like Alabama and Georgia, have also been successfully challenged in court.
So there's a track record of legal hurdles for these kinds of laws. What about the federal versus state control aspect?
H.R. 22 represents a pretty significant assertion of federal authority over the nuts and bolts of voter registration, which is traditionally administered by states and counties. While the NVRA set federal standards, this bill imposes a much more specific, rigid, and burdensome mandate compared to the NVRA's approach, which aimed for flexibility alongside access.
Creating operational headaches for the state and local officials who actually have to run elections.
Definitely. The operational challenges, the costs, the legal risks, they all fall primarily on those state and local election administrators.
Given all that, if H.R. 22 were to pass, what's the likelihood of lawsuits?
Extremely high. It's almost guaranteed that the law would face immediate and widespread legal challenges the moment it was enacted.
On what grounds?
Based on the precedents, challenges would likely argue it places an unconstitutional undue burden on the fundamental right to vote, that it violates equal protection principles due to its potentially disparate impact on certain groups, and that it conflicts with other constitutional provisions. The private right of action clause would also likely fuel litigation.
This has been incredibly informative about H.R. 22. To really grasp the scale of the proposed change, maybe we should quickly recap the current system it seeks to replace. How does voter registration generally work now in the U.S. under federal law?
Sure. So the current federal framework is mostly built on the NVRA and HAVA. The absolute baseline is you must be a U.S. citizen to vote in federal elections. That's paramount. And everywhere except North Dakota, you need to register first.
And citizenship verification currently relies mainly on
It relies mainly on the attestation system under the NVRA.
Yeah.
When you fill out the registration form, whether it's paper, online, or at the DMV, you check a box and sign, affirming under penalty of perjury that you meet the eligibility requirements, including citizenship.
What about the ID requirements people sometimes hear about?
Those primarily come from HGV, and they're actually quite narrow. They generally apply only to first-time voters in a federal election within a jurisdiction who registered by mail and whose identifying numbers, like driver's license or SSN4, couldn't be verified beforehand. And critically, they need to show ID when they vote, not when they register.
And the types of ID are broader than just citizenship documents.
Yes, HEV allows for various forms, including current utility bills, bank statements, government checks, or other government documents showing name and address, alongside photo IDs. And if your DLN or SSN4 was matched during registration, you're exempt from this first-time voter ID requirement at the polls.
So election officials do perform checks, just not typically by demanding documents from the applicant up front?
Correct. They use the information provided on the form, usually a driver's license number or the last 4 digits of a Social Security number, to verify the applicant's identity and eligibility against various government databases. These can include the MV records, the Social Security Administration database, statewide voter files, sometimes DHS citizenship data, death records, and USPS change of address records.
So for the vast majority of people registering, they fill out the form, provide an identifier like a driver's license number, attest to their citizenship, and the verification happens mostly behind the scenes.
That's generally how it works in most states currently for federal registration. While some states might ask for ID if you register in person, it's typically not the specific primary documentary proof of citizenship that H.R. 22 mandates for all federal registrants across all methods.
And online registration often uses those same identifiers, like driver's license info, to verify against DMV records.
Exactly. Online systems usually cross-reference the provided DLN or state ID number and sometimes SSN4 with state databases to confirm identity and eligibility before the registration is finalized. It's important to distinguish these registration verification steps from the separate issue of voter ID laws that apply when you show up at the polling place to vote.
Okay, so contrasting that with H.R. 22
Yeah.
really is a radical shift, isn't it?
It's a fundamental departure. H.R. 22 imposes a universal requirement for all federal election registrants, regardless of method, to present specific physical citizenship documents at the time of registration.
Applying to everyone every time, potentially even for address updates.
The language suggests it applies broadly to applications for registration, and it flips the burden entirely onto the applicant to produce these documents, rather than relying on attestation backed by official verification. Standard IDs, like most driver's licenses, simply become insufficient proof of citizenship for the act of registering.
It feels like it's adding a whole new, very demanding layer onto the process.
That's a good way to think about it. It layers a significant burdensome requirement on top of existing processes like attestation and database checks, increasing complexity and potential barriers.
Which seems counter to the original NVRA goal of simplifying things.
Right, it moves away from the simplification goals of NVRA and potentially creates redundancy. You attest and show documents, and officials still likely run database checks. There's also a risk that this intense focus on one specific aspect, citizenship documents, might overshadow other equally important aspects of ensuring accurate and accessible voter rolls.
This has been a really thorough walkthrough of House Bill 22 and its context with House Resolution 294. If we were to boil it down, what's the core takeaway here?
I think the main takeaway is that House Bill 22, the Safeguard American Voter Eligibility Act, represents a really significant proposed change to federal voter registration. It would shift from our current system, which primarily relies on voters affirming their citizenship under penalty of perjury, to one demanding specific documentary proof of citizenship from everyone registering for federal elections.
And we've heard the arguments for it focusing on preventing non-citizen voting and boosting election confidence, alongside the very serious concerns about potentially disenfranchising millions of eligible citizens, creating huge administrative burdens, and almost certainly triggering major legal battles.
Exactly. It really throws into sharp relief that ongoing tension in election administration. How do you balance measures aimed at security with the fundamental need to ensure broad, equitable access to the ballot box for all eligible citizens?
It definitely leaves us with a lot to think about regarding that balance. Thanks so much for breaking this down for us.
My pleasure.
And thank you all for joining us for this look at these pieces of legislation. We hope it gives you a clearer picture, and we encourage you to continue exploring how these kinds of proposals might impact different communities and the voting process itself.